The starting point is to look closely at the alleged environmental harms that Azerbaijan seeks to portray as racial discrimination. Azerbaijan complains of a multitude of alleged harms, which it says have occurred in what it calls the liberated territories. To take them in the order in which they appear in the memorial, Azerbaijan complains of, first, destruction and degradation of forests, second, destruction and degradation of natural monument trees, third, destruction and pillage of water infrastructure, fourth, destruction and degradation of agricultural land and vineyards, fifth, degradation of land and water quality through strip mining activities, and sixth, neglecting and mismanaging the water infrastructure, particularly the Sarsang reservoir, allegedly affecting the Azerbaijani population living downstream. On Azerbaijan's case, all this harm allegedly occurred in the 3 decades in which it describes Armenia as having occupied the territory. Azerbaijan describes Armenia as conducting an ethnic cleansing campaign through the First Nagorno-Karabakh War to create an ethnically pure Armenian settlement in Nagorno-Karabakh. And its case is that virtually no Azerbaijanis remained in that territory after 1994. Time and again in the memorial, we see Azerbaijan referring to the fact that the alleged environmental damage was done during this period of so-called occupation. So, for example, it claims that 8,900 hectares of forest were verified as lost from the then occupied territories during the occupation period. It says, of the registered natural monument trees in the then occupied territories, at least 38 were destroyed during Armenia's occupation. It says the total amount of agricultural land lost from productivity during the occupied period between 1995 and 2015 was 54,544 hectares. And it says that hundreds of kilometers of irrigation canals in the liberated territories were abandoned, unmaintained, and blocked during Armenia's occupation. Now, Armenia would draw your attention to 3 particular features of this situation. On Azerbaijan's case, firstly, when the alleged racial discrimination took place, Armenia controlled the relevant area, ethnic Armenians lived there, and ethnic Azerbaijanis did not. In other words, the alleged victims of this racially discriminatory environmental harm were not there to experience it. And with respect, that's quite a peculiar scenario for racial discrimination. And secondly, on Azerbaijan's case, ethnic Azerbaijanis were allegedly excluded from the territory by Armenia, not through any discriminatory harm to the environment, but through sheer military force. So, for example, Azerbaijan's memorial speaks of Armenia violating CERD by preventing Azerbaijanis from accessing those territories throughout the entire course of its almost 30-year occupation. And it goes on to allege that the armed forces of Armenia, including its installed regime, sealed off the then occupied territories from the rest of Azerbaijan using physical barriers, military fortifications, landmines, and snipers, and deploying threats and intimidation along the line of contact and beyond to reinforce the message that Azerbaijanis could never return to those territories. And this leads to a third element. On Azerbaijan's case, the so-called occupation was no mere temporary state of affairs. On the contrary, according to Azerbaijan, Armenia intended this situation to be permanent. As we just saw on screen, the alleged intention was, quote, that Azerbaijanis could never return to those territories. So in other words, on Azerbaijan's case, the alleged environmental harm was never intended to be experienced by Azerbaijanis. It was going to be experienced by a permanently settled ethnic Armenian population. So turning to the law, to survive this jurisdictional phase, Azerbaijan needs to show that the acts and omissions of which it complains are capable of amounting to a distinction, exclusion, restriction, or preference, that is, a differential treatment of human beings. Then it needs to show that any such thing was based on ethnic or national origin. The first requirement here is fundamental. CERD is a human rights instrument. It concerns, as the court has made clear, a differentiation of treatment of which human beings are the object. Azerbaijan's submission is that Armenia violated Articles 2 to 7 of the CERD through, quote, the establishment of an ethnically pure Armenian settlement, notably by, quote, differential destruction and degradation of the natural environment in areas where Azerbaijanis resided prior to Armenia's ethnic cleansing and occupation. But the fact that areas from which Azerbaijanis departed were allegedly the subject of environmental harm does not constitute, Armenia says, any differentiation of treatment of human beings, since on Azerbaijan's own case, no Azerbaijanis were living in those areas when the relevant acts allegedly took place. In short, there could be no differential treatment of ethnic Azerbaijanis as compared with others, since on Azerbaijan's case, there were no ethnic Azerbaijanis present to experience such treatment. So that's the first way in which Azerbaijan's case, by which the absent Azerbaijanis were subjected to discrimination, runs into trouble under the CERD. The next problem is that, assuming for the sake of argument that there was a differentiation of treatment of human beings, it would only be capable of falling under the CERD if Azerbaijan could establish that the acts in question are capable of constituting a distinction, exclusion, restriction, or preference based on one of the grounds prohibited by Article 1 of the CERD. Now, Azerbaijan does not suggest that the harms it complains of were based on any of the protected grounds in the sense that that was their stated purpose. We recall that the court indicated in its judgment of January this year in the first Ukraine versus Russia case that a measure whose stated purpose is unrelated to the prohibited grounds contained in Article 1, Paragraph 1, does not constitute, in and of itself, racial discrimination by virtue of the fact that it is applied to a group or to a person of a certain race, colour, descent, or national or ethnic origin. Here, Azerbaijan has not asserted that specific forests were cut, particular mines were exploited, or individual farms were degraded for the stated purpose of discriminating against ethnic Azerbaijanis. Instead, Azerbaijan tries to argue that the purposeful concentration of such development and resulting environmental harms in areas that were predominantly populated by Azerbaijanis prior to occupation, while areas that had been populated by Armenians remained comparatively unharmed, was based on the fact that the populations of these areas were Azerbaijani. Indeed, says Azerbaijan, the only credible inference is that Armenia's conduct was purposely aimed at Azerbaijanis as an ethnic or national group, end of quote, even though Azerbaijan's case is, of course, that Azerbaijanis didn't live in the relevant areas at the time. Now, here it may be useful to pause and consider the proper approach at jurisdiction stage when dealing with such assertions. It is one thing to accept, for this week's purposes, the facts alleged by Azerbaijan. That is, their allegations as to what was done and where. That is a necessary part of the exercise. But it is quite another thing to ask the court to accept completely unsupported characterizations of the purpose behind the acts complained of. As you've seen, Azerbaijan claims that there was a purposeful concentration of environmental harm in areas where ethnic Azerbaijanis previously lived. But it provides no evidence to justify its use of the term purposeful. It simply asks the court to proceed on the basis that decisions about where to mine, for example, or to log, or to rebuild infrastructure, were not based simply on the location of the resources in question, or the existential needs and the right to development of the beleaguered and isolated ethnic Armenian population. Rather, in the words we just saw, it claims that these were, quote, based on the fact that the populations of those areas were Azerbaijani in the past. Perhaps alive to the problem of showing that acts were aimed at people who were allegedly not there to be aimed at, and who Azerbaijan says Armenia was blocking from returning in the future, Azerbaijan also sets great store by its allegations that Armenia mismanaged the water supply from the Sarsang reservoir. Azerbaijan's focus on these allegations is no doubt in part because, unlike the other alleged harms, this is one which, on its case, had effects outside the so-called occupied territories. But it provides yet another example of an allegation where Azerbaijan has provided no evidence at all that the conduct was based on ethnic or national origin. Worse than that, Azerbaijan's own evidence undermines that proposition. The resolution of the Parliamentary Assembly of the Council of Europe, on which Azerbaijan relies heavily, characterizes the alleged mismanagement of the reservoir as a, quote, tool of political influence and a, quote, hostile act by one state towards another. Now, if that resolution is correct in its characterization, which Armenia would of course not accept, then any such action was taken for political purposes, not for a purpose that relates to ethnic discrimination. The next legal hurdle faced by Azerbaijan is the question of whether the acts complained of are capable of having the purpose or effect of nullifying or impairing Azerbaijani's equal enjoyment of human rights and fundamental freedoms. Here again, Azerbaijan's case collapses under the weight of its logical inconsistencies. We can begin by recalling the court's careful analysis in its recent decision in the first Ukraine versus Russia case, which you see on your screens. The court noted that racial discrimination may result from a measure which is neutral on its face, but whose effects show that it is based on a prohibited ground. The court noted that where convincing evidence shows an apparently neutral measure produces a disparate adverse effect on the rights of a protected person or group, then this may amount to racial discrimination unless such an effect can be explained in a way that does not relate to the prohibited ground in Article 1, Paragraph 1. And the court emphasised that mere collateral or secondary effects on persons who are distinguished by one of the prohibited grounds do not, in and of themselves, constitute racial discrimination within the meaning of the Convention. In light of the court's consistent case law on this issue, there are several points which Armenia asks you to bear in mind when considering Azerbaijan's environmental claims alongside the purpose or effect requirement. First, the showing of disparate effects must still be directed at establishing that the conduct complained of was based on a prohibited ground. Second, the showing of a disparate effect will not suffice if there is an objective and reasonable explanation for the disparity that does not relate to the prohibited grounds. And third, mere collateral or secondary effects on a particular group are not enough. As Counsel for Azerbaijan put it last week, in general terms, unless the allegations and evidence relied on show something other than mere collateral or secondary effects, the court should conclude that it lacks jurisdiction ratione materiae over the claims because they are not capable of constituting racial discrimination within the meaning of Article 1.1. As to the issue of discriminatory purpose, we've already noted that Azerbaijan's own case is that the environmental harm it complains of took place during a 3-decade so-called occupation by Armenia of territory which it intended permanently to settle with ethnic Armenians to the exclusion of Azerbaijanis. In these circumstances, it is just as hard for Azerbaijan to show that the alleged harmful acts had a discriminatory purpose as it is to show that those acts were based on ethnic or national origin. And again, we can take the allegations relating to the Sarsang reservoir as an example. Relying solely on inferences, Azerbaijan claims that Armenia's alleged mismanagement of the water supply from the reservoir, assuming that Armenia had any control over it, purposely targeted ethnic Azerbaijanis to suffer from a lack of water. But again, such an inference is contradicted by Azerbaijan's own evidence, along with basic logic. The explanatory memorandum to the 2016 Parliamentary Assembly of the Council of Europe resolution reports that the Sarsang reservoir, located in Nagorno-Karabakh, supplied water to, quote, about 138,000 inhabitants of Nagorno-Karabakh and about 400,000 people in other areas of Lower Karabakh in Azerbaijan. It states that the damage to the reservoir occurred during the war, 1992 to 1994, most likely because of explosives, while fighting took place around the canal. The fact is that after the war, the damage was never repaired. In any event, under these circumstances, water from the Sarsang reservoir cannot be used for irrigation by anyone until the canal has been repaired. So in other words, on Azerbaijan's own evidence, the problems with the water supply from this war-damaged reservoir affected, among others, the entire ethnic Armenian population of Nagorno-Karabakh. In those circumstances, it's logically impossible, we say, for Azerbaijan to show that the purpose of the alleged mismanagement of the reservoir was to disadvantage only ethnic Azerbaijanis living further downstream. This ignores the inconvenient fact that those living in the immediate vicinity of the reservoir, the entire ethnic Armenian population of the area, suffered just as much, if not more. And so the Sarsang reservoir example illustrates, we suggest, some key flaws in Azerbaijan's attempts to argue that the acts it complains of had any discriminatory purpose. Given this problem, it's not surprising that Azerbaijan falls back on the argument that those harms amount to discrimination because they had a disparate adverse effect. This argument also fails, however, for a number of reasons. Most fundamentally, it fails because Azerbaijan cannot actually show any disparate adverse effect of the acts it complains of. And here we must turn back to Azerbaijan's contorted case on the facts. I've already addressed you on the illogicality of Azerbaijan's attempt to characterize acts as discriminatory, which, on its own case, were done on territory where Azerbaijanis did not live, and to which Armenia allegedly sought to prevent them from returning by military force in violation of multiple provisions of the CERD. In such circumstances, quite obviously, any negative effects of environmental harm in the area fell on the actual residents, the ethnic Armenians. Azerbaijan's attempts to address this logical problem, when Armenia pointed it out, are instructive. It argues that environmental harms were purposely directed at Azerbaijanis and Azerbaijani-populated areas because they were inhabited by persons of Azerbaijani ethnic or national origin, and that regardless of purpose, such harms have had and continue to have a disproportionate effect on Azerbaijanis as a distinct group defined by ethnic or national origin. But it's important, we say, to pay close attention to what is actually meant by Azerbaijanis and Azerbaijani-populated areas. This is a sleight of hand. We've already seen Azerbaijan's claims that the areas in question had been, quote, ethnically cleansed of the Azerbaijani population and remained so during the 30 years of so-called occupation. So Azerbaijan is clinging to the argument that it can found a discrimination claim on the allegation that environmental harm occurring in various forms across the entire occupied territory was worse in areas in which a particular group used to live but no longer did, and to which Armenia allegedly did not intend them to return. Now, the stark question for the court is whether such factual allegations can meaningfully amount to a disparate adverse effect on those absent people, to the extent that this can found a discrimination claim under the CERD. Armenia submits that they cannot, and that to conclude otherwise would amount to an unprecedented departure from the careful and structured analysis which the court has adopted in previous racial discrimination cases. As we saw when we looked at the court's recent analysis in the Ukraine versus Russia case, the showing of a disparate effect will not suffice for these purposes if such an effect can be explained in a way that does not relate to the prohibited grounds. Now, Azerbaijan's position appears to be that at jurisdictional stage, it has free rein to speculate as to the reasons for any disparate effect. But the analysis which Armenia invites the court to carry out in this case does not trespass in any way on the underlying factual allegations. Armenia's case is simply that, as I explained, on Azerbaijan's own factual case, there is no logical basis for finding any differential and adverse impact on ethnic Azerbaijanis. Now, Azerbaijan attempts to advance certain types of rights in support of its claims for environmental harm. In this context, it's worth taking a moment to look at Azerbaijan's arguments on the right to health, as this is, as Armenia says, illustrative of Azerbaijan's flawed approach to the whole of its discrimination claim. Azerbaijan says much about the right to health, but their case really centres on the assertion that the right to health includes the right, quote, to return to a healthy environment, which is crucial to human health. Since this is a CERD claim, of course the right to health is not a freestanding right subject to adjudication. Azerbaijan must still show discrimination, meeting all the criteria I've just discussed. And it must show, so far as that discrimination is said to have occurred in the field of the right to health, that that claim properly falls within the scope of that right. But there is evidently nothing in the right to health that includes the right to return to live on particular land in a particular condition. And Azerbaijan's attempt to piece together scraps from cases about indigenous peoples, which it rightly does not claim includes Azerbaijanis, fundamentally miss the mark. The court will recall that last week, Azerbaijan argued that the views of the CERD committee should be disregarded by the court. Despite its professed scepticism about the committee's work, however, Azerbaijan relies heavily on, for example, the committee's decision regarding the Western Shoshone tribe in the United States. This is said to support the argument that an ethnic group has the right to return to an area where it is not currently physically resident. Azerbaijan is plainly wrong about this. The decision makes clear that, despite some encroachments on their lands, the Western Shoshone people have reportedly continued to use and occupy the lands and their natural resources in accordance with their traditional land tenure patterns. In fact, the precise concern, as we see on screen, was that the Western Shoshone people were experiencing, quote, intimidation and harassment by the US authorities in a number of aspects of their life on the territory, as you see listed on screen. And in an even more striking omission, Azerbaijan fails to explain that this case was decided in the context of the rights of indigenous communities, which, the committee noted, possess the right to own, develop, control and use their communal lands, territories and resources. Such rights clearly entail a far broader set of obligations on state parties not to infringe on indigenous land. Azerbaijan rightly does not argue that the ethnic Azerbaijani population that lived in the so-called occupied areas counts as an indigenous community. So the third case law referring to such communities and their very specific rights and needs offers it no assistance, let alone helping to establish the right, as it puts it, to return to a healthy environment. Azerbaijan also attempts to support its case on the right to health with quotes from various third recommendations and concluding observations. Thus, Azerbaijan argues that the right to public health protected under Article 5(e)(4) of the CERD encompasses the right to the, quote, highest attainable standard of physical and mental health. But again, Azerbaijan fails to show that this standard includes the right to return to a healthy environment. Indeed, none of the authorities cited by Azerbaijan remotely contemplates such a right. Without a right to return to a healthy environment, Azerbaijan's factual allegations, namely that Armenia's deliberate infliction of environmental harm in, quote, Azerbaijani districts has a, quote, disproportionate and continuing effect on people of Azerbaijani ethnic or national origin who continue to be prevented from exercising their right to return home, end quote, are not capable of falling within the scope of the CERD. And Azerbaijan's arguments on the right to property fare no better. All of the authorities cited by Azerbaijan on the right to property refer to the collective land rights of indigenous, tribal or minority peoples living in the relevant region. And again, Azerbaijan rightly refrains from arguing that ethnic Azerbaijanis possess collective rights to land in Nagorno-Karabakh. And Armenia respectfully submits that any contrived claim that the alleged environmental harm violated the right to property should be rejected. In conclusion, Mr. President, members of the Court, Armenia submits that Azerbaijan's claims of discrimination arising out of environmental harm fall outside the scope of the CERD and thus outside the Court's jurisdiction ratione materiae. I have sought to demonstrate the flawed logic which underpins them and the multiple ways in which Azerbaijan seeks to contort the law. Azerbaijan's factual allegations, even if taken as true, are simply not capable of amounting to a coherent claim of discrimination against an ethnic group which was, on its own case, not located in the relevant territory and never intended to return there. Azerbaijan cannot show, firstly, that there was any differential treatment of human beings, secondly, that the harms it alleges were based on ethnic or national origin, or, thirdly, that any such harms had any discriminatory purpose or disparate adverse effect. The whole of Azerbaijan's claims are premised on the illogical idea that those who did not live in the territory at the time suffered more from these alleged widespread environmental harms than those, ethnic Armenians, who did. Armenia respectfully requests the Court to reject these contrived arguments. Mr. President, members of the Court, I thank you for your attention and I now ask you to call upon Professor Sicilianos.
I thank Ms. MacDonald for her statement. I now invite Professor Linos Alexander Sicilianos to take the floor. You have the floor, sir.
Mr. President, Madam Vice President, members of the Court, it is an honor to appear before the Court today on behalf of the Republic of Armenia. I shall present the last argument in Armenia's first round oral pleadings. This argument is very simple. I will be addressing the reasons why Armenia's preliminary objections can and should be decided in this preliminary objection phase and not deferred for decision alongside the merits. Mr. President, it is undisputed that pursuant to Article 79 ter of the Rules of Court, the Court may declare that a preliminary objection in the circumstances of the case, does not possess an exclusively preliminary character and may reserve decision on such an objection for a later phase of the proceedings. Conversely, when an objection does possess an exclusively preliminary character, it has to be decided by the court in the preliminary objections phase. As the court explained in military and paramilitary activities in and against Nicaragua, it is quite clear that when objections are exclusively of that character, they will have to be decided upon immediately. This requirement is a result of the amendment of the relevant rule in 1972. The history of this process is eloquently explained by Judges Tomka and Crawford in their separate opinion to the court's 2019 judgment in certain Iranian assets. In short, under the prior formulation of the rule, the court had a discretionary power to join the objection to the merits. This unrestricted prerogative to delay decision on objections was being exercised by the court in a way that prompted criticism. Indeed, one member of the court wrote that it amounted to an easy way out, which was represented by the neutral and in some cases diplomatic answer of joinder, but which really constituted a postponement of any decision. For example, in the 1964 judgment on preliminary objections in the Barcelona traction case, the court deferred decision on the applicant's standing to the merits. 6 years later, after substantial further litigation between the parties, the court finally decided that the applicant indeed lacked standing. It is thus inappropriate for Azerbaijan to invoke that case, which is an example of the undesirable application of the prior formulation of the rule and, in fact, inspired its amendment. Indeed, following Barcelona traction, recommendations were made in the Sixth Committee of General Assembly that the court should be encouraged to take a decision on preliminary objections as quickly as possible and to refrain from joining them to the merits unless it was strictly essential. This approach was then enshrined in the 1917-2 reformulation of the rule that remains in force today, although it was slightly rephrased in 2019. Accordingly, the court's power to refrain from deciding a preliminary objection or question is circumscribed to objections or questions that truly cannot be decided in this first phase of the proceedings. To cite the court's judgment in territorial and maritime dispute Nicaragua versus Colombia, in principle, a party raising preliminary objections is entitled to have these objections answered at the preliminary stage of the proceedings. The only exception is when the court does not have before it all the necessary facts to decide the question, or ruling on the objection requires a pronouncement on the merits. Objections based on strictly legal questions, which are not intertwined with the merits, are prime examples of the type of objections that should be decided at the preliminary objections stage. Armenia respectfully submits that in this case, the court should resist the temptation offered by Azerbaijan to defer consideration of Armenians' objections to the merits phase. As I will explain, all preliminary objections of Armenia are of an exclusively preliminary character. I turn now to Armenia's first objection concerning the court's jurisdiction ratione temporis under the third. Mr. President, members of the court, it is difficult to think of a more exclusively preliminary question than the question posed by Armenia's first objection. As Mr. Martin explained this morning, Armenia is respectfully requesting that the court rule on two questions of principle. The first question is whether the critical date for assessing the court's jurisdiction ratione temporis is 15 September 1996 or 23 July 1993. According to Armenia, Article 22 of the Third does not afford the court jurisdiction over Azerbaijan's claims pertaining to a time when it was not a party to the Convention. The critical date must therefore be 15 September 1996, the date of entry into force of the Convention for Azerbaijan. On Azerbaijan's case, Article 22 does extend the court's jurisdiction over its claims erga omnes partes to a time when it was not a party to the Convention. According to Azerbaijan, the critical date would thus be 23 July 1993, which is the date of entry into force of the Convention for Armenia. Deciding this question simply requires the court to undertake an exercise of treaty interpretation in light of the relevant principles of international law. There is no need to assess any factual evidence or trespass on the merits in any way. As explained by Mr. Martin, Armenia is not asking the court to assess whether each and every one of Azerbaijan's allegations fall within or outside the court's jurisdiction. Instead, Armenia is asking the court to provide a pronouncement of principle that will allow the parties to know where they stand and to plead their cases on the merits efficiently and effectively. This means formulating their allegations, defenses, and analysis of the evidence in light of the applicable critical date. If the parties are required to present alternative cases on the merits, depending on which critical date applies, it will create unnecessary confusion and inefficiencies. The same considerations apply equally to the second question that Mr. Martin addressed, which concerned whether Azerbaijan's claim on ethnic cleansing falls within the court's jurisdiction, even if the critical date is set in 1996. Here too, the court need not get into the facts other than to know their absence. As Mr. Martin explained, Azerbaijan does not allege that any populations were displaced after 1994, and its theory of composite breaches cannot extend the court's jurisdiction to cover facts or events that occur before the critical date. Azerbaijan invokes in this context the Croatia versus Serbia genocide case, arguing that it sets a precedent for the court to join to the merits a preliminary objection concerning acts on violence spanning the critical date. There is, however, a drastic difference between that case and the present one. In Croatia versus Serbia, an armed conflict straddled the critical date, which fell in the middle of Croatia's allegation of a, quote, a pattern of conduct increasing in intensity throughout the course of 1991. In contrast, in the present case, the critical date falls more than 2 years after the cessation of hostilities and the conclusion of a ceasefire agreement. The considerations of admissibility addressed by Professor Darjean, whether concerning judicial propriety or extinctive prescription, are also exclusively preliminary. They concern purely legal questions that, by their very nature, have to be addressed in this preliminary stage. Mr. President, members of the court, ruling on Armenia's first and second objection is not just a matter of efficiency, but also a question of fundamental fairness. Defining the temporal scope of Azerbaijan's claims at this stage will allow Armenia to determine whether or not to bring counterclaims in its counter-memorial. As is well established in the court's jurisprudence, counterclaims must be sufficiently connected to the principal claim and must form part of the same factual complex. This includes a requirement that the relevant facts occurred during the same period of time. In formulating counterclaims, it is critical for Armenia to know the permissible temporal scope of the court's jurisdiction over Azerbaijan's claims. This brings me to Armenia's objections concerning the court's jurisdiction ratione materiae. Mr. President, members of the court, Armenia's objections ratione materiae also possess
an exclusively preliminary character and should be resolved in the present phase of the proceedings. I will explain why this is the case with regard to both Azerbaijan's claims pertaining to landmines and to the environment. First, as Mr. Salonidis explained, Azerbaijan's claims pertaining to landmines and booby traps can be disposed of very easily. The court has rejected all of Azerbaijan's corresponding requests for provisional measures, finding that the rights invoked by Azerbaijan were simply not plausible. Despite Azerbaijan's attempts to reformulate its case at the last minute, the court should regard its claims as remaining the same as they have been all along. The court has all the necessary elements before it to decide Armenia's objection as it relates to landmines and booby traps. All that the court needs to do is interpret the cert and apply it to Azerbaijan's factual allegations accepted as true pro tem. Taking Azerbaijan's case at its highest, Armenians' alleged use of landmines is not capable of amounting to a distinction based on national or ethnic origin within the meaning of Article 1.1 of the cert. Nor do the facts that Azerbaijan points to show on their face that Armenians' alleged use of landmines and booby traps is capable of having a discriminatory purpose or effect. In this context, there is nothing left for the court to examine at the merits stage. As Mr. Salonidis mentioned already, judicial propriety and efficiency supports disposal of Azerbaijan's contentions at the preliminary phase. If an applicant's allegations, even if proven, are not capable of breaching the treaty in question, then there is no need for the court or the parties to devote time and resources proceeding to the merits. This is all the more true in the case at hand, in which the court has examined the same factual allegations concerning landmines and booby traps under the same convention, not once, not twice, but 3 times. Second, Armenians' objection concerning Azerbaijan's environmental claims is similarly of an exclusively preliminary character and should be decided in this phase of the proceedings. As Mrs. MacDonald meticulously demonstrated, the factual context as advanced by Azerbaijan, along with our legal points as to how Azerbaijan's allegations very obviously fall outside the scope of the cert, should lead the court to dispose of these environmental claims at this jurisdictional stage. In particular, those facts, even accepted as true, are not capable of establishing racial discrimination. Azerbaijan's allegations are, with respect, illogical. The court does not need to proceed to the merits to understand that environmental damage occurring in lands inhabited by one ethnic group cannot constitute racial discrimination against another ethnic group that did not live there and, in Azerbaijan's case, was not expected to return. Azerbaijan has simply not articulated on the facts a claim capable of breaching the cert, and its legal arguments in this regard, interpreting the cert, fare no better. Azerbaijan distorts the underlying substantive obligations of the cert by inventing new rights that do not exist. This is most obvious with respect of the so-called right to return to a healthy environment. Azerbaijan has presented no support for the proposition that cert protects such a right. This is because no such support exists. There is no mention of such a right anywhere in the cert committee's dozens of opinions on individual communications and general recommendations, or even in its hundreds of concluding observations. Nor is there any support for Azerbaijan's attempt to invoke a collective right to property that has been dealt with only in the specific context of indigenous peoples. In this sense, the Court can take comfort in finding at this preliminary stage that Azerbaijan's claims fall outside its jurisdiction and that it needs no additional elements to reach this conclusion. Mr. President, members of the Court, I thank you for your kind attention. This concludes my remark and today's submissions on behalf of the Republic of Armenia. Thank you very much.
I thank Mr. Sicilianos, whose statement brings the sitting to a close. The oral proceedings in the case will resume at 10 a.m. tomorrow, Tuesday, 23rd of April, when Azerbaijan will present its third round of oral argument. The sitting is adjourned.